what the court just ruled, we can ask about things that Ms. Hilton said to Mr. Copeland during that ex parte meeting. We just can't label an ex parte. This is what I'm concerned with. There's a lot of confusion and I think misunderstanding of this immunity. I understand the order that was granting him use and derivative use immunity. However, Ms. Hilton articulated to Mr. Copeland in chambers much more than that. For instance, my understanding of law, and Your Honor, I know that you've dealt with these issues more than me, the statute of limitations is not what we normally think it to be. It's not from the date of the offense. It's told if there's no evidence of who committed the offense. Mm-hmm. That's one, the perpetrator has to be known. So Ms. Hilton said, for instance, we'll use the barbershop shooting. Ms. Hilton said, oh, all this stuff is older than 4 years, so you can never be prosecuted. He could be prosecuted for the barbershop shooting.
But here's the thing.
They would just have to put a tolling provision.
That's not relevant either, because it is not the fact that the statute of limitations may or may not have run that prevents the state from prosecuting him for something he wants to get on the stand and confess to. It is the grant of immunity that prevents that. So regardless of the correctness or incorrectness of statute of limitations comments, they cannot use anything he gets on the stand and confesses to because they granted him immunity, or the court has granted him immunity.
But in my mind, here's the difference. The state has made a deal with the, quote unquote, I'm not calling the man the devil, but that's the saying. And there's a difference between them saying, oh, we're giving you use and derivative use immunity versus them saying, we will absolutely not prosecute you. They have basically, I don't know if they checked with Rich Homie Kwan's father, but they've basically given this man carte blanche to never be prosecuted for anything he says. And if I was representing Kenneth Copeland later on and they indicted him for something like this, I would say, y'all must be crazy. Y'all got in the back room and told this man, you guys are never prosecuting him. So they've done more than giving him use immunity. They've given him blanket immunity for everything. And that, to me, is fertile ground for impeachment and cross-examination. And I think the jury needs to know they want Jeffrey Williams, they want Shannon Stillwell, they want these people so bad that they gave Mr. Copeland just full reign to run around Atlanta, do all these things, and as long as you get up on the stand, we're never going to prosecute you. And I think that's relevant.
Okay, well, they didn't give him full reign to go do things he hasn't done yet. So, I mean, let's not get too far afield with this.
Well,
you may explore any kind of interest he might have in testifying in a way that might be beneficial to the state, although I don't think that's happened anyway, because you could explore bias. You're entitled to do that, but we're not going to, this is not a trial about how the state handled Mr. Copeland or how Judge Glanville handled Mr. Copeland. This is a trial about whether these defendants, whether the state can prove that these defendants committed the acts that they allege them to have committed.